Well, good afternoon, and thank you for joining us. Today is January 21st, 2025, and this is our first virtual town hall of the year. My name is Michael Gault, and on behalf of our team at Bell Carrington, Price, and Gregg, I would like to welcome you to this particular virtual town hall to talk about the Gillis Hill Road Widening Project. Let me take just a couple of seconds here, and I'll put my name and Lindsay Carrington, an attorney on our eminent domain team, and my email address and direct phone number, so that if throughout this virtual town hall some questions arise that I do not address, I'd invite you to reach out to me directly, and so I can connect you with the right person on our team to help answer those questions and to make sure that you receive the information that you need to make intelligent decisions about this project and its potential impact to your property. So, if you're here with us tonight or watching this recording at a later date, you're here naturally worried about Project U5798, specifically U5798 subsection B. This is the portion of Gillis Hill Road widening that is slated to start construction later this year. It has been in right-of-way acquisition for some time, but it's likely that many of you still have pending cases. Maybe those cases have not been able to be settled with the department at this point. Maybe you are working toward or you're in condemnation and there's still no resolution for you. But regardless of what stage you're in, if there's an eminent domain impact or a condemnation case that might impact your property, that's why we're here, to give some brief background information, to tell you about how that process generally works, and ultimately what we can do for you here at Bell Carrington. So naturally, if you live in and around this project, you've heard about it before. You've been inundated with the construction on portion A, as I've seen pictures and videos of here recently. And so you know that it's going forward, but this project has a nearly $2.5 million right-of-way acquisition budget. And that tells us and our research team that many of you landowners are going to be impacted. Naturally, if a road widening is going from 2 lanes to 4 lanes with raised medians, then private property owners on both sides of that existing 2-lane road will likely have property that has to be acquired through new right-of-way or through new easement of some sort in order to be able to allow the state or the county to widen that portion of road. And that's what's impacting you as landowners in this case. Does the government have the right to do that? Yes, they do. In short, their right to eminent domain is the right of the government or any governmental entity to take private property for a public purpose. There's no question that the improvements of infrastructure like roadways have been determined to be public purposes to meet that definition. And so then the next question is, what rights do you have as landowners? Well, your most important right is the right to just compensation. And put simply, that means that even though the government has the right to take your property for a public purpose, they have to pay you fairly and adequately for what they're taking from you. That is the definition of just compensation. Unfortunately, determining that true value of just compensation is never easy. There is no formula. There's no mathematical equation that we can plug in A plus B and spit out the just compensation. Those analyzations are complicated. You often have to look at the value of the property, the value of the improvements. What's the current use? Is it residential, commercial, industrial? How does access change? Is the roadway getting closer to the house? Will safety decrease? Will noise pollution increase? These are all just samplings of some of the items that our team looks at when we go to analyze the amount of just compensation that is owed or potentially owed to a landowner. Now, once that determination is made, don't expect any governmental entity, the NCDOT, a county construction or road corps, anybody, to just say, yep, you're right, Mr. Landowner or Mrs. Landowner, here is your check. There is often a lengthy negotiation. Sometimes those cases get into what we call litigation. That just means that a condemnation action is filed, and then you're in the court system arguing and negotiating and fighting over, legally speaking, of course, the amount of money that the government needs to pay you. We have a team of lawyers who specialize in eminent domain cases in North Carolina and throughout the Southeast. And that's that's what we do. That's the value that we provide our landowners, is identifying the impact to the property, analyzing the financial implications to the property or potential economic losses, and ultimately come up with the just compensation calculation. And then we go to fight for you. We, if necessary, our lawyers file answers in the appropriate court in North Carolina. Once those condemnation actions are filed, we go through the legal procedure, and ultimately we try to work with various departments to make sure that we settle these cases. Sometimes settlement is not possible. Sometimes you as a landowner have to utilize your ultimate right to trial to have these amounts determined, but we don't ever try to jump the gun and get there before it's necessary. It's oftentimes more beneficial for the landowner economically when it comes to looking at cost of litigation to settle these cases before trial. But we're ready and we have trial experience should the need arise. A couple of questions that landowners normally have on projects like this. The first is that I'd like to assure you that our team is standing by for a free, no cost, no obligation initial consultation. It is impossible for me to tell you and address certain specific impacts to properties in a forum like this, in a setting like this, but we are fortunate to have some software at Bell Carrington that will allow myself or a member of our team to pull up your property and the impact to your property in real time while we're on the phone, so that I can see how serious is this impact, what does the property look like now, and we can have an informed decision about that potential impact to the parcel. Those obligations are there for you to answer questions, for us to give you some additional parcel-specific information, and generally to answer whatever we can answer for you in a setting that's more one-on-one and more detail-oriented. Those are free, no cost, no obligation. And during those consultations, we can explain the second question that most landowners have, and that is attorney's fees. There's a valid concern from many landowners that attorney's fees may eat up any new money or new just compensation that the department may be willing to pay. And so they're hesitant to go through that process or procedure to get a net gain of zero. Fortunately, we've worked down a solution with our fee structure, and that is that we charge landowners a contingency fee. That means basically that ultimately an offer is going to be made to you for the impact to your property, and we work to try to increase that offer. Our fee is a percentage of the increase. It is a contingency fee based on us being able to increase that offer from the department. If we're not able to increase that fee or increase that amount of just compensation, then the landowner, generally speaking, is not on the hook for any attorney's fee. Now, that can change depending on a case-by-case basis. Those percentages sometimes do change depending on the nature and the use of the property. And so we would invite you to reach out to us for that no cost, no obligation consultation to find out what your impact may look like and how our fee structure will apply to you specifically. But generally speaking, again, there's no out-of-pocket costs. There are no upfront retainer fees, and we don't bill hourly. And so our fee is based on a percentage of the outcome of the case, be that a settlement or a verdict at trial. So again, Michael Gault, Lindsay Carrington, Bell Carrington, I appreciate you all being here for this Gillis Hill Road Part B project. This widening is impacting many of you, as you've already seen on subsection A, and this portion B will continue to affect many of you, regardless of where you are in the process. If it's pre-litigation, pre-condemnation, you've just received an offer, if somebody reached out to you to tell you that an offer is coming, or if you've been served with a condemnation notice, it's important to know that in North Carolina, you have a set amount of time to answer those notices. And regardless of where you are in the spectrum of eminent domain or condemnation, we have somebody on our team that is prepared to sit down with you, talk to you, answer your questions, and hopefully have us work with you throughout this impact to your property to make the best of a bad situation. Appreciate your time. Thank you for being here. Don't hesitate to shoot me an email or give us a call. You can also find us at Bell Carrington, eminentdomain.com. I'll put that in the chat box. There are a number of ways to reach us there. You can schedule a direct appointment or find phone numbers and email addresses there as well. Thank you again. Look forward to hearing from you.